All right, welcome back. I was worried I had my computer muted, couldn't hear me, thought my mic wasn't working, but that's a me problem. So yeah, welcome back. I have a short but hopefully exciting episode for you. So basically, after two straight marathon streams, I don't have it in me to do a super long one. So basically, the primary purpose of today's stream, well, video, I guess isn't a live stream. So the primary purpose of today's video is to finish the Las Vegas Police Department's LVMPD's reply on their 12B6 motion, um, which unfortunately my internet didn't want to cooperate and let me finish recording a couple days ago. So I've backtracked a little because I don't know at what point it functionally stopped. So I'm going to be continuing from this B. But first, I have some exciting news. So I'm going to announce it here, even though it's I'm not covering anything from that case today. But um, well, without burying the lead, Professor Scofield has a GoFundMe set up. So I received an email earlier today from her friend Chris saying, "Hey, she's got this up. You've mentioned before that yeah, she should set one up. So here it is." And I responded to Chris and I said, "All right, I'm just gonna need two quick things. I'm going to need confirmation from Professor Schofield because, I'm not gonna put my reputation on the line to you guys without it. And also I need basically a plan for any excess funds, on the chance that she achieves her goal and funds the lawsuit. Basically, if there are excess funds or if she uh, actually recovers attorney's fees at the end, you know, basically, I don't want you guys to be a windfall for Professor Schofield, deserving as she may be. That's not what it's for. It's to pay her attorney's fees, make sure she can continue. So I got confirmation from Professor Schofield. She reached out to me late this evening, and it's her. She also CC'd her attorney, Wendy Olson, on it. So that's good confirmation for me. I'm going to harass the other law tubers who have covered the case, and also other non-law tube people who have covered it, like Moist Critical and Atozy and a couple others. Uh, Try to get them to spread the word about the GoFundMe. So yeah. Oh, and uh, if there are excess funds at the end, it'll go to the scholarship funds set up at the University of Idaho in the name of the four murder victims. So, uh, conveniently, that's actually one of the two suggestions I made. So, yeah, there's that. You should donate. It's a terrific cause. So, with that, let's jump back to Vegas. So, like I said, I've backtracked a little just to make sure. Plus, I can't remember exactly where I ended, but I know I went a little after this. But let's just finish this extremely well written reply brief and then call it a day, and then, you know, we'll have more insanity later on. So, B. DeCastro makes several false claims about LVMPD defendants' motion. LVMPD defendants accepting DeCastro's allegations as true on a 12b5, that should read 12b6, but that's an easy typo to make, on a 12b5 motion to dismiss is not the same as admitting to DeCastro's allegations. Sections 4, 5, 6, and 8 of DeCastro's opposition claim the LVMPD defendants have admitted to a number of DeCastro's allegations by accepting the factual allegations within the First Amended complaint as true for purposes of the instant motion. As this court is well aware, LVMPD defendants are required to accept DeCastro's allegations as true in the context of an FRCP 12b6 motion to dismiss. LVMPD defendants accepting DeCastro's allegations as true for the limited purpose of moving to dismiss the claims for failure to state a claim upon which relief can be granted cannot be construed as an admission to any allegation within the First Amended complaint. Accordingly, contrary to DeCastro's arguments, LVMPD defendants have not admitted to anything in the motion. LVMPD defendants did not misstate DeCastro's claims in the motion. In Section 7 of DeCastro's opposition brief, he argues defendants largely assume state law claims where there are also federal law claims and skip over all state constitution claims in plaintiff's First Amended complaint. To the contrary, the LVMPD defendants transcribed the causes of action within DeCastro's First Amended complaint accurately. See ECF number 15 and compare, which is the motion to dismiss, and compare it to ECF number 13, the First Amended complaint. DeCastro has not asserted state constitution claims in the First Amended complaint. I agree. I couldn't find any. I actually did go back and look. I couldn't find any, so they're not asserted. Him saying there are state constitution claims in his opposition to the motion to dismiss, well, they're not pled. So how can they exist if they're not in the complaint? But LVMPD defendants' clerical error in referencing the original complaint does not negate LVMPD defendants' substantive arguments. In Section 10 of DeCastro's opposition brief, he argues the motion cites the original complaint at ECF number 1 instead of the active First Amended complaint at ECF number 13, and makes arguments about that now irrelevant document. Even though, like I said before I was cut off, ECF number 1 is actually his request for ECF filing access. The original complaint is ECF number 2. In actuality, the LVMPD defendant's single citation to ECF number 1 was a clerical error and has no impact on the substance of the LVMPD defendant's substantive arguments. Moreover, the single citation to ECF number 1 references paragraphs within the First Amended complaint, not paragraphs within the original complaint. As such, it is apparent that the reference to ECF number 1 is a clerical error. And going further, I'd actually, I would assume that the clerical error is not accidentally putting ECF number 1 because, you know, they'd have been referencing ECF number 2. So my guess is they actually went to put ECF number 13, but had a sticky key, or, you know, they missed the 3 as opposed to intentionally putting the 1. But as I said, when I was reading Delete Lawz opposition, the absolute mess that it was, you know, they referenced ECF number 13, ECF number 13, ECF number 13. They were obviously referring to ECF 13. The motion's legal argument is not testimony from an attorney. In section 14(1) of De Castro's opposition brief, he asserts plaintiff's counsel attempts to enter testimony without a declaration. Assuming that De Castro meant LVMPD's defendant's counsel, LVMPD defendant's counsel's propounding of legal argument is not the same as LVMPD defendant's counsel entering testimony. Now let's look at footnote 1 on section 14. De Castro's opposition brief contains 2 section 14s. Here, the LVMPD defendants are responding to section 14 of the ECF number 27 on page 7, lines 17 through 18. Or are they paragraphs? I can't remember in his. But so let's think about this for a second. He does this twice. I can't remember if this is the second time it's mentioned or the first. But there are 2 double numbered paragraphs or sections. So let's apply the same logic from right here. So let's say LVMPD's argument is invalid because they had a transcription error citing ECF number 1, which is, like I said, the motion for ECF access. So their argument is invalid because they missed the 3. Well, then at least one of the section 14s would have to be invalid by his logic. Wouldn't you think? Same with, I think it's section 16. It might be section 13. I can't remember. Either way, let's keep moving. De Castro fails to state 42 U.S.C. section 1983 Fourth Amendment or state law false arrest claim upon which relief can be granted. First and eighth causes of action. Fourth Amendment false arrest. In section 11 of De Castro's opposition brief, he argues his false arrest claim survives because he alleges that he was arrested without probable cause. However, the entire premise of the LVMPD defendant's motion is the allegations within the first amended complaint demonstrate Officer Bork did, in fact, have probable cause to arrest. De Castro is asserting a conclusion of law, such as that Officer Bork lacked probable cause to arrest, must give way to the factual content of the first amended complaint, which demonstrates De Castro refused to comply with Officer Bork's commands to stand back and thereby obstructed the traffic stop. In section 12 of De Castro's opposition brief, he argues the LVMPD defendants failed to cite the statute he violated and only allude to obstruction. ECF number 27, paragraph 6, or page 6. De Castro further argues the cases the LVMPD defendants cited within the Ninth Circuit are inapposite because those plaintiffs were not participating the exercise of their constitutional rights. However, the cases cited by the LVMPD defendants clearly establish the conduct alleged in De Castro's first amended complaint, namely his asserting a right to stand 15 feet away from an active traffic stop and refusing to leave after an officer had asked him to do so, constitutes probable cause of obstruction under the clearly established law. See Kelly versus LVMPD from July of 2014. It's an unpublished case, so I'm assuming it. Well, yeah, it's going to be a federal case, so it's going to be District of Nevada Federal Court. And see also Tsao versus Desert Palace, Inc. from the Ninth Circuit in 2012. State law false arrest claims. In Section 14.2 of DeCastro's opposition brief, he asserts the LVMPD defendants are not entitled to discretionary immunity on his state law false arrest claim, and there is no qualified immunity under Nevada law. DeCastro is correct. There is no qualified immunity under Nevada law. However, as argued in the motion, the LVMPD defendants are entitled to discretionary immunity on DeCastro's state law false arrest claim pursuant to NRS 41.032. See Gonzalez versus LVMPD from Nevada State Court in 2013, which held that an officer's decision to arrest based on a matched description in a facially valid warrant was entitled to discretionary immunity. And see Martinez versus Marushak from Nevada Supreme Court, I believe, in 2007, which says a decision is entitled to discretionary immunity under NRS 41.032 if the decision, 1, involves an element of individual judgment or choice, and 2, is based on considerations of social, economic, or political policy. Here, as was the case in Gonzalez, LVMPD defendants meet both prongs of the Berkowitz-Gobert test established in Martinez. Officer Bork's decision to arrest DeCastro based on the probable cause of obstruction was part of a policy consideration that required analysis of multiple social, economic, efficiency, and planning concerns, including public safety. See Ortega versus Reyna from Nevada 1998, which concludes that no civil liability attached to a state trooper's decision to arrest a driver for allegedly refusing to sign a traffic ticket because the decision to do so was a discretionary decision requiring personal deliberation and judgment, and was thus entitled to immunity under NRS 41.032. And the footnote above that I ignored said 2 Section 14s in DeCastro's opposition brief. But that last quotation, of course, was from Cote versus Washoe City, Nevada, 1992. Well, sorry, that last wasn't, but it's further bolstered by Cote versus Washoe City, which said the decision of whether to make an arrest is largely discretionary. Qualified immunity on the federal false arrest claim is appropriate here. DeCastro does not oppose the substantive argument of LVMPD defendants' contention the subject officers are entitled to qualified immunity on DeCastro's false arrest claim. Instead, he asserts it is too early to enter qualified immunity, ECF number 27. However, whereas here, DeCastro was warned to stop obstructing and refused to comply with that order, there is no clearly established law which would implicate the constitutionality of the subject arrest under the Fourth Amendment. In Section 13, footnote 3 of the opposition, DeCastro argues Officer Bork is not entitled to qualified immunity because a right can be clearly established on the basis of common sense, and because qualified immunity does not extend to a public official who enforces a statute that is patently violative of fundamental constitutional principles. However, DeCastro's first amended complaint clearly demonstrates the arrest in this case does not present the kind of novel, common sense, factual circumstances that could deprive Officer Bork of qualified immunity. Let's see. DeCastro's opposition brief contains 2 Section 13s. Here, defendants are responding to Section 13 beginning at ECF number 27, page 7, colon 19. DeCastro fails to state a 42 U.S.C. Section 1983 equal protection claim upon which relief can be granted. Second cause of action. In Section 15 of the opposition, DeCastro argues he has sufficiently pled an equal protection claim, arguing he was discriminated against as a member of the press and also that he constitutes a class of one under Village of Willowbrook versus Olek from the Supreme Court in 2000. DeCastro's conclusory statements within the First Amendment complaint, the defendant officers would have treated him differently if not but for his skin color, status as a member of the press, and political affiliation and viewpoints are not sufficient in the context of federal pleading standards. DeCastro argues Lacey versus Maricopa County, 9th Circuit, 2012, stands for the proposition that conclusory allegations about differential treatment are sufficient for pleading an equal protection claim. However, Lacey unambiguously reinforces the principle a plaintiff must allege some facts, either anecdotal or statistical, demonstrating similarly situated defendants could have been prosecuted but were not. Here, DeCastro merely alleges a conclusion the officers would have treated him differently if not but for his class, but does not allege any similarly situated individual could have been arrested but was not. Additionally, DeCastro argues he fits a class of one claim under Village of Willowbrook versus Olek. Again, the factual allegations within the First Amendment complaint are insufficient for this court to infer DeCastro has been intentionally treated differently from others similarly situated. DeCastro has failed to identify a comparable individual who was treated more favorably. In conclusion, DeCastro has failed to explain how his First Amendment complaint adequately states a claim upon which relief can be granted for his equal protection claim, and as such, this court should dismiss the claim. DeCastro fails to state a 42 U.S.C. Section 1983 First Amendment retaliation claim upon which relief can be granted. Third cause of action. In Section 16 of the opposition, DeCastro argues he has properly alleged a First Amendment retaliation claim because other similarly situated individuals engaged in some sort of protective speech but had not been arrested. As argued in the motion, and as discussed supra, meaning above, probable cause existed for the arrest. According to DeCastro, he was arrested for protesting his arrest, meaning he was already arrested when he was protesting his arrest. Thus, his argument is simply that he was arrested for protesting his lawful arrest. The same deficiency exists here as exists with DeCastro's equal protection claim. DeCastro has not identified any other individuals similarly situated who were not arrested. Even if DeCastro's allegations within the First Amendment complaint are construed such that he is alleging First Amendment retaliation for filming the officers, DeCastro has also not identified any other individuals who filmed LVMPD police officers conducting a traffic stop within 15 feet of the traffic stop and received preferential treatment. Thus, DeCastro has failed to allege prima facie facts supporting a First Amendment false arrest retaliatory arrest claim. DeCastro fails to state a 42 U.S.C. Section 1983 claim for Monell or supervisor liability upon which relief can be granted. Fourth cause of action. De Castro's Monell claims fails to state a claim upon which relief can be granted. As argued in the motion, the First Amended complaint contains no identification of a policy that, when enforced, caused the alleged constitutional violation. See Baxter by Baxter versus Vigo County School Corporation, Ninth Circuit, 1994. De Castro instead generally pleads LVMPD trains its officers to carry out unlawful detentions and arrests. However, De Castro's conclusory assertions are contradicted by the factual allegations within the First Amended complaint. Namely, the LVMPD defendants violated LVMPD's formal use of force policy and interactions with the public policy. De Castro has failed to plead facts demonstrating any of the following. 1. An express policy that, when enforced, causes a constitutional deprivation. 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3. Constitutional injury caused by a person with final policy-making authority. So, I know I'm beating a dead horse here, but we've got to go back to Iqbal. The full citation, Ashcroft versus Iqbal. Because not only does it lay out the absolute standard along with Twombly for the standard of pleading required under Rule 8 to survive a 12b6 motion, but Ashcroft versus Iqbal actually is very, 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 very similar to the allegations that Delete Lawz is making here, because he's making it, we'll just directly quote Attorney Anderson here. De Castro's conclusory assertions, we'll quote the first line. De Castro instead generally pleads LVMPD trains its officers to carry out unlawful detentions and arrests as a conclusory statement. Now, Delete Lawz thinks that this conclusory statement has to be taken as true. But we know from both Twombly and Iqbal that conclusory statements are not taken as true. Its factual allegations are taken as true for the purposes of a 12b6 motion. But so what was the crux of the actual Iqbal case? Well, Mr. Iqbal alleged that the Department of Justice, run by former Attorney General John Ashcroft, that's the Ashcroft in Ashcroft versus Iqbal. So Iqbal alleged that former Attorney General John Ashcroft, heading the Department of Justice, as the Attorney General does, had a systematic policy of racial discrimination against Muslims. But that was his allegation. It was just the conclusory statement. The Department of Justice has a formal policy of discriminating against Muslims. Now, this was in the post 9/11 world. They probably, that there was a very good chance that they did have such a policy. Now, my uncle is from Iran. He has a very Iranian name. Their phone was obviously obviously tapped by someone after 9/11. There would be clicks there, they'd hang up and then pick up the phone again, and someone was still on the other line that wasn't who they were talking to. The only reason he would, his phone would be tapped, that any of us could think of, is he's Persian. So, Mr. Iqbal may have had a point, but it was a conclusory statement. So the Supreme Court said, yeah, that's not good enough. Come to us with factual allegations. The same thing applies to Delete Lawz here. Him saying that LVMPD has this pattern and practice to have its officers carry out unlawful detentions and arrests, that's conclusory, and it cannot be taken as true without some factual allegation. Hence his nickname, Captain Conclusory. So, LVMPD defendants request this court reject DeCastro's attempts to rely upon conclusory allegations intended to recite the elements of the claim, and demand DeCastro plead particularized facts if he intends to state a Monell claim upon which relief can be granted. DeCastro fails to state a 42 U.S.C. Section 1981 claim upon which relief can be granted. Fifth cause of action. In Section 19 of DeCastro's opposition, he argues that LVMPD defendants misunderstand a Section 1981 claim, and he has clearly alleged he did not receive police services in an equal way, nor could he enjoy the services of the barbecue in an equal way, including the use of the parking lot. However, DeCastro fails to explain how the facts of this case give rise to a 42 U.S.C. Section 1981 claim in light of the case law provided by LVMPD defendants in the motion. LVMPD defendants stand by their argument as explained in the motion, and DeCastro has not provided any argument which would preclude dismissal of this claim. DeCastro has failed to allege a 42 U.S.C. 1981 claim upon which relief can be granted because DeCastro was not attempting to contract with the LVMPD defendants for any service and was not denied the rights to contract for any service. CEG, Lindsay versus SLT Los Angeles, LLC, 9th Circuit, 2006. And they've got a point. Once he was released, he could go right back to Roll and Smoke Barbecue and park in their parking lot or eat their barbecue. He just couldn't interfere with police investigations in their parking lot. He could have gone back the very next day, and so long as Roll and Smoke Barbecue didn't say, "Get lost, we don't like you," he could have ate there. He probably would have had to hold a fundraiser first, but that's beside the point. DeCastro fails to state a Nevada state law invasion of privacy claim upon which relief can be granted. 9th cause of action. LVMPD defendants agree with DeCastro his invasion of privacy claim can only survive if there was no probable cause to arrest DeCastro, because otherwise it would be a legal search incident to arrest. However, as discussed supra, the first amended complaint makes clear that probable cause existed to arrest DeCastro. DeCastro fails to state a Nevada state law negligence claim upon which relief can be granted. 10th cause of action. In Section 21 of DeCastro's opposition, he argues LVMPD defendants are not entitled to immunity on his state negligence claim because the law has changed since Nevada's Ortega decision in 1998. As argued in the motion, the primary reason this claim fails is probable cause existed for the arrest, and thus the claim fails on that basis alone. Additionally, DeCastro fails to explain how the analysis of discretionary immunity in relation to arrests under the Berkowitz Gobert test established in Martinez versus Maruchat would lead to a different result than was reached in the cases cited by the LVMPD defendants. See Ortega and Cody, which says the decision of whether to make an arrest is largely discretionary. As such, DeCastro's first amended complaint fails to state a claim for state law negligence upon which relief can be granted. Conclusion: LVMPD defendants brought the instant motion because DeCastro has not pled facts sufficient to state a claim upon which relief can be granted for the following claims. 1. 42 U.S.C. Section 1983 Fourth Amendment false arrest and imprisonment claim. 2. Nevada state law false arrest and imprisonment claim. 3. 42 U.S.C. Section 1983 14th Amendment claim. 4. 42 U.S.C. Section 1983 First Amendment claim. 5. 42 U.S.C. Section 1983 Monell municipal liability claim. 6. 42 U.S.C. Section 1981 intentional discrimination claim. 7. Nevada state law invasion of privacy claim. And 8. Nevada state law negligence claim. Based on the foregoing, LVMPD defendants respectfully request the court grant the instant motion and dismiss the aforementioned claims. Dated 23rd day of June, 2023, Marquise Auerbach, signed Craig R. Anderson, Esquire. And this is a rather long certificate of service because, well, as we saw in the last video, he's playing games with service by requesting ECF access, which would require service through ECF, which will just email him automatically. But then he didn't follow through with that, trying to fake out Mr. Anderson, I would presume, because that's what he does, is he plays games. So that's where I'm going to leave this one today. Like I said, do my best to keep it short. It's a very well-pled reply brief, so it didn't need a ton of commentary. If you haven't watched the previous video, obviously watch that first. It's long. It makes my brain explode, but it also has the first part of this. And as I mentioned earlier, support Dr. Scofield, the plaintiff in the other main case I'm covering, Scofield versus Guillard. She's a deserving cause. I want to, I have a selfish vested interest in her taking this case to its conclusion because, I'm fascinated and want to keep covering it. And, I'm sure you guys, at least those of you who do watch that case, fewer of you watch that than Delete Lawz coverage, but that's beside the point. Those of you who do watch, I'm sure want to see it go to its conclusion as well. And even aside from that, even if you're not watching, Dr. Scofield is just a great example of, the damage that an unhinged person can cause to, to someone they just pick at random and constantly defame them and double and triple and 150 yuple down on them and on defaming them. And Dr. Scofield deserves to be able to fight back and see it to its conclusion. So please support her if you're able to. If it means you have to go without, don't. But if you're able to support her, please do. And support me by doing all the YouTubey things, like, share, subscribe, bribe your friends to do the same. And I will see you very soon for the next one. Bye bye.